Good afternoon, and welcome to the Wagner Law Group's series of webinars on the Secure Act. My name is Regina Mandl, and I'm the leader of the Trust and Estates team at the Wagner Law Group. I am working remotely from home, so please pardon interruptions that we may experience. Today's webinar will focus on how the Secure Act impacts estate planning and administration. You will find a list of our other webinars on the firm's website, www.wagnerlawgroup.com. All webinars are free. Before I begin, I want to say a few words about what is on everyone's mind, the coronavirus pandemic. Many of you are now working remotely, and the usual interactions with colleagues are no longer available. My own firm has closed its bricks and mortar offices, but we are open for business working from our homes. I personally find it to be gratifying to be able to keep busy during this difficult time. At the end of the presentation, I will give you my observations as to how I personally will be handling estate planning in this difficult time. Setting every community up for retirement enhancement, known as the Secure Act, was signed into law just before the end of 2019. Actually, it was December 20th, just before the Christmas holidays, having received bipartisan support from Congress and was effective January 1, 2020. This webinar will focus on the Secure Act and how it affects estate plans and certain other matters that are important to individuals in their personal lives. I'll be paying particular attention on the impact of inherited retirement assets under estate plans, including assets held in trust. The impetus for the law is very clear. The federal government wants more revenue, and the Secure Act, as we will see, is intended to harvest the low-hanging fruit. Before January 1, 2020, it was possible for the beneficiary of an inherited IRA or 401k to take distributions over that beneficiary's lifetime. This was called the stretch. The lifetime stretch is very valuable because the retirement assets can grow tax-free and the accumulations accelerate. The Secure Act has changed the rules so that most beneficiaries now will be required to take all inherited retirement assets within 10 years of the date of the death of the decedent. Unlike the lifetime stretch, the 10-year rule does not require that all money be taken out each year. It only needs to be paid out by the end of year 10. But for tax reasons, most of the time, the beneficiary will not want to wait until year 10 because then the money will be larger and the taxes more. There are 5 exceptions to the 10-year rule, and these beneficiaries are called eligible designated beneficiaries. The 5 exceptions are a surviving spouse, minor children of the decedent, only until the age of majority, after which the 10-year rule applies. Beneficiaries who are disabled, beneficiaries who are chronically ill, and beneficiaries who are not more than 10 years younger than the decedent. Let's look at these 5 exceptions with greater detail. For the surviving spouse, the rule really hasn't changed, and the surviving spouse who is eligible will still have the opportunity to take a lifetime stretch. On the death of the surviving spouse, whatever is left in the fund will have a 10-year rule apply. Minor children are treated differently from the other 4 beneficiaries. The age of majority is not defined. Presumably, it will be according to state law. But even then, the definition is not clear. Take, for example, in Massachusetts, where I practice law. A child is generally thought to be emancipated at age 18. Under the Uniform Transfer to Minors Act, the age is 21. And a child becomes emancipated for divorce law purposes at ages 18, 21, or 23. So when you're talking about minor children of the decedent, we're not quite sure when the starting point is. Another big exception to the minor children is grandchildren. Remember, we're talking about of the decedent. So grandchildren are excluded. Also, what about stepchildren in a blended family, nieces or nephews, godchildren? All of these appear not to be included in this exception, and they will be subject to the 10-year rule. The maximum amount of time that retirement funds can be tied up is the age of majority plus 10 years. So if the age of majority is 18, that means that the funds can be distributed, must be distributed, by the time the child is age 28. For many clients, they are going to be very disappointed to know that their careful planning over the years to provide for grandchildren who, if they thought were going to get the lifetime stretch, is no longer going to be a possibility. And so you'll see a lot of very unhappy people trying to figure out what to do. Given the pain that we are all going through right now, it becomes particularly disheartening. Trust for children. And this often is the case because you don't want minor children in particular to have control over these assets until they're quite ready. If the funds are already held in trust, you need to review to see if they still work. And your choices are a conduit trust or an accumulation trust. A conduit trust requires a faster payout because it has to be distributed each year to the child. An accumulation trust accelerates the tax bill for the trust and likely will have a higher tax bill. With an accumulation trust, you are allowed to keep the money in the trust and not distribute it to the child, but there is a bite, and the bite is big. The tax rate for 2020 for trust income, presently anyway, is 37%, starting at income of only $12,950. Generally, individual tax rates will be less, even if there is a kiddie tax. On the death of the child who has not reached the age of majority, the 10-year rule applies as of the date of the child's death. We often direct that retirement funds for minor children be held in trust. However, for smaller amounts, you might want to consider using beneficiary designation forms naming a custodian. The exceptions 3 and 4, beneficiaries who are disabled or chronically ill. I start by saying I do not have depth of knowledge as to these two areas by any means, but I refer you to the law, beneficiaries who are disabled is section 72M7, and it's pretty clear that Social Security disability benefit recipients will be eligible. Under 72M7, an individual who is unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death or to be of long continued and indefinite duration. An individual shall not be considered to be disabled unless he furnishes proof of the existence thereof in such form or manner as the Secretary may require. Recipients, as I said, of Social Security benefits likely will qualify, but there may be others, and it's hoped there will be further IRS guidance. Beneficiaries who are chronically ill. Section 7702BC2A. This is a bit more complicated. The requirements are met if there is a certification that as of such date, the period of inability described is an indefinite one, which is reasonably be expected to be lengthy in nature. In subsection A, chronically ill is defined as an individual who has been certified by a licensed health practitioner as, 1, being able to perform without substantial assistance from another individual at least 2 activities of daily living for a period of at least 90 days due to a loss of functional capacity. 2, having a level of disability as determined under the regulations to the level of disability described in Clause 1. Or requiring substantial supervision to protect such individual from threats to health and safety due to severe cognitive impairment. Such terms do not include an individual otherwise meeting the requirements of the preceding sentence unless within the preceding 12-month period, a licensed healthcare practitioner has certified that such individual meets such requirements. And there is a whole list of activities of daily living, eating, toileting, transferring, bathing, dressing, continence. All of these are familiar to some of you because it sounds very much like long-term care, and in fact it is. So I urge you to take a look for yourselves at the law, and I'm sure we're going to be hearing more about this from the IRS. Both the chronically ill and disabled beneficiaries appear to have some additional benefits that other eligible designated beneficiaries will not have. One benefit is that unlike other see-through trusts, it appears that you will be able to have a trust divide into subtrusts when there is a chronically ill or disabled beneficiary. So that beneficiary will not have to be the sole beneficiary of the trust to get the lifetime stretch. Before Secure, you had multiple beneficiaries who would apply the life expectancy of the oldest beneficiary for determining the applicable distribution period. This raises a whole host of questions about what happens when an eligible designated beneficiary is mixed with an ordinary designated beneficiary, now limited to the 10-year rule. The dates of determination. Both disabled and chronically ill status is determined as of the date of the participant's death. If someone becomes disabled or chronically ill during the 10-year period, it appears that the 10-year rule will still apply and the beneficiary will not have the lifetime stretch. On the death of any of the beneficiaries who are disabled or chronically ill, the 10-year rule applies and the distributions must be made within 10 years of the date of the death of the beneficiary. As I said when I first began this segment, The treatment of beneficiaries who are disabled or chronically ill is a topic unto itself and is not covered in depth here. Exception number 5, beneficiaries who are not more than 10 years younger. They get the lifetime stretch, and it may be suitable to benefit a younger sibling or a younger significant other, provided that they are not more than 10 years younger than the participant. Let me give you some examples. Let's take Jane and Margaret. Jane wants to leave her retirement funds to her wife, Margaret. Jane can name Margaret the primary beneficiary of her retirement funds, and Margaret will enjoy the lifetime stretch. But what if Jane and Margaret are not married? Well, if Margaret is disabled, chronically ill, or less than 10 years younger than Jane, Margaret can still have the lifetime stretch. If not, then the distributions to Margaret must be done by December 31 of the 10th year of the anniversary of Jane's death. Consider this for a minute. In addition to the benefits of having the extensive marital deduction for estate planning, marital status may provide the surviving spouse or partner with significant tax savings benefits under the lifetime stretch versus a 10-year payout rule. Let's talk now a little bit about minor children. Jane decides to leave her 401k to her children, half to her son Joe and the other half to her niece Sally, who has been living with Jane and Joe since Sally's mother died, and named Jane in her will as Sally's legal guardian. Jane considers Sally and Joe both to be her children. Assume the age of majority is 18, and that Jane died when Joe was 12 and Sally was 2. On Jane's death, until Joe reaches the age of 18, Joe will be treated the same as if he had a lifetime stretch. But when Joe turns 18, it converts to the 10-year rule. Joe's stretch will end when he is 28. Joe gets 16 years. It appears that Sally, on the other hand, will have to receive all her distributions under the 10-year rule. So the distributions for Sally will end when she is 12. Sally gets 10 years. Consider this for a moment. Depending on the amount, the difference between a payout schedule of a 16-year stretch and a 10-year stretch can be very significant and could make a real difference in what these two children raised together in the same household by the same person will actually receive. Disability. Sally develops a condition which makes her incapable of working. Sally applies and receives Social Security disability benefits, and this happens while Jane is still alive. Sally can have the lifetime stretch. Well, what happens if Sally's disability develops a year after Jane's death? Jane has provided that Sally will receive 50% of her IRA, but now Sally is subject to the 10-year rule. I say pick your poison about these trusts, not because trusts are poisonous, but because the rules have been so changed that you now have to decide between paying more taxes or giving out more money. Basic rule. A trust may qualify as a beneficiary of a retirement plan, provided that the trust beneficiaries of the retirement funds are all human beings and the payout rules are followed. Conduit trusts require payouts to the beneficiary. Given the 10-year rule, some parents may not want their children to receive everything as young as age 28. Accumulation trusts allow the trustees to make discretionary payments, which is something that is often desirable. But the tax rates for trusts are very high. As I said earlier, they ratchet up to 37% very quickly. Trusts could provide distributions to be made to individuals and taxed at the individual rate and not the trust rate. Some clients, especially those with relatively modest estates, may prefer to make children the second-tier direct beneficiary, naming a custodian, and place other, more flexible assets, such as life insurance, in the trust. Both the conduit trust and the accumulation trusts under the 10-year rule will have an increased cumulative tax payment compared to the lifetime stretch. For marital trusts, because you need to distribute all of the income only to the surviving spouse, you can only use a conduit trust if you want the marital deduction because of things such as the Q-tip rules. For all other situations, you could use either a conduit trust or an accumulation trust, but you have to follow all of the rules. Please note, trust planning with retirement benefits is very complex and you need to use great care. The above is just the tip of the iceberg when it comes to making a trust the beneficiary of a retirement plan. For further information, I refer you to Natalie B. Choate's excellent book, Life and Death Planning for Retirement Benefits, available at www.ataxplan.com. And I heartily recommend that you read it before trying to do any trust planning of your own with retirement benefits. We're hoping that there should be and will be greater clarity through regulations or other published IRS guidance. So hope does spring eternal. Well, not all the news is bad. I want to give you some information that will be helpful in designing an estate plan. The age for required minimum distributions has been changed to 72, and the age cap for funding traditional IRAs has been eliminated so that individuals who are over 70 and a half are now eligible to make contributions to a traditional IRA if they otherwise qualify. The notion of making charitable contributions through qualified charitable distributions, that can still continue, and it may be starting at age 70 and a half, even if the new rules say you don't have to take required minimum distributions until age 72. A bit of good news for charity. Also noteworthy, 529 plans may be used to repay up to $10,000 in student loans and expenses for apprenticeships. I believe that that is a lifetime limit at the moment. Birth or adoption of a child, an individual may withdraw from an eligible defined contribution plan or IRA up to $5,000 on the birth or adoption of a child without being subject to the early withdrawal 10% penalty. The new rules apply to all estates for decedents dying as of January 1, 2020. For estates of decedents dying on or before December 31, 2019, there may still be the opportunity to reposition the benefits through disclaimer, but the clock is ticking. Remember, disclaimer rules require that you act within 9 months of the date of death. What should we do now? Certainly notify clients of the change in the law. Ask that they bring all beneficiary designation forms to you and that they personally confirm that the plan administrator has acknowledged receipt. If it hasn't been accepted by the plan administrator, it's not going to hold, and there's always a possibility that the money will be going to the wrong party or to the estate, which has a 5-year rule. Clients who have trusts intended to hold inherited retirement benefits should have those trusts reviewed. There may be little or nothing to do, but unless you look at the trust itself, you're not going to know. Another idea is to consider doing illustrations. What would a beneficiary now receive on an after-tax basis with a reduced 10-year stretch? Compare that to other assets and see if you want to consider rebalancing. I want to share with you some of my own personal thoughts and observations. For existing clients, I wish to ask if they have lifetime documents and confirm that they do. By lifetime documents, I mean healthcare proxies, durable powers of attorney, HIPAA release authorizations, and living wills. And if not, I want to provide them with whatever is needed. Ask them to review the beneficiary designations and title to assets. At the moment, only the most dire of circumstances would prompt amending wills and trusts. I then am dividing the document preparation into 2 parts. I usually do all drafts together, but under these circumstances, we are sending out the lifetime documents first: the healthcare proxy, durable power of attorney, HIPAA authorization, and living will. We will go and do the more complex wills and trusts later. However, it's entirely possible that a simple will suffice for now. I'm thinking particularly when it comes to naming the guardian of children and directing where you want your money to go in a general way. Trusts are wonderful, but they are also complicated, and I just don't believe they have priority at the moment. Much can be done with a will and a review of beneficiary forms together. I'm giving priority to urgent cases, serious illness or hospitalization, clients in high-risk groups, by age, pre-existing medical conditions and pregnancy, and first responders in the medical, law enforcement, fire, and military arenas. How am I doing this? We are sending the lifetime documents electronically with very specific instructions for printing and signing. We'll be available by telephone to assist. As we are all now working from home, we are doing virtual consultations by FaceTime, Skype, or Zoom. As of this recording, which is done on Sunday, March 22, notarization cannot be done remotely in Massachusetts. However, there are significant emergency efforts underway in Massachusetts to allow remote witnessing and notarization of documents. Keep in mind that a will in Massachusetts does not have to be valid to be notarized, does not have to be notarized to be valid. All you need is 2 witnesses. A self-proved affidavit can be added later. Take a look at statute MGLC 190B, section 5-204B, which gives you very specific roadmap information. So if you have a client who just doesn't have access to a notary, but does have 2 witnesses, have them sign with the witnesses. You can add the self-proved affidavit later. To quote Doris Kearns Goodwin, who was quoting Eleanor Roosevelt, I apologize for the typo there. It's Roosevelt. These are no ordinary times. Please stay calm and carry on. It's important to reassure each other and the clients, and we will all get through this together. I thank you for your time this afternoon.